Yellow lights are coming.
Thank you.
Thank you. Mr. Abramowitz?
Good morning, Your Honors. May it please the Court, my name is Joseph Abramowitz. I represent the appellee in this case, Pablo Montes, but because of the procedural format of the case, this Court allowing the petition for further appellate review, I argue first. I think it's important to note, and the things I'd like to point out to the Court first, is this Court's statement in the case of Commonwealth v. Levesque, that in almost all cases, the issue of recklessness is for the jury. The issue of recklessness in this case was decided by the jury in favor of the plaintiff against the MBTA. I would like this Court to take a look, if you would please, at the appendix that contains the exhibits. It's Appendix 11, because I believe this sets the scene for the facts and the totality of the circumstances that were existing on the early morning hours of July 4th, 1999, when this unfortunate incident occurred. This accident occurred as a train, a Blue Line train, was proceeding from the Revere Beach station to the Wonderland station. If this Court first looks at Exhibit 13, which appears on appendix page 21, you will see the tracks in question, which basically gives the operator a straight shot, an absolutely unobstructed, clear view from where the train is starting out of the station to the location of the accident. If you then look at Exhibit 15, which is appendix page 22, it gives the opposite view, looking back. These are pictures taken by the MBTA. It gives the view looking back toward the station from the area of the accident. The next exhibit, Exhibit 16, page 23 of the appendix, takes the same view looking outward from the train station toward the area of the accident, down at the level where the train operator is operating the train. It should also be kept in mind that the jury had an actual video taken in the early morning hours as part of the pretrial discovery in this case. They saw a video taken in the early morning hours showing exactly the view that the operator had as he pulled out of the train station.
Could I understand what you did, but where you are leading with this, clarify for me. Is it that, I forget the name of the operator of the train?
Montes.
Is it that Montes should have seen Mr. Montes there? Or was your argument to the jury that he did see Mr. Montes there before the impact?
My argument was that his conduct was both negligent and reckless, and the facts of the argument supporting, or the facts supporting that argument were the following. We have written rules by the MBTA that Mr. Montes...
With all due respect, you were not answering my question. Did you ask the jury to draw the inference that Mr. Montes saw Mr. Montes and, knowing he was there, ran him over? That's one theory. Or was the inference you asked the jury to draw that he didn't see him, which proves that he was not looking forward? What did you ask the jury to infer, from this?
I argued the latter point, Your Honor.
That he didn't see him because he was looking elsewhere, wasn't looking where he was supposed to be looking.
Correct.
Okay.
And speeding.
Right. All right.
So my argument essentially is that there were Mr. Montes agreed that the regulations at issue that he violated were safety regulations. He agreed that the purpose of the safety regulations was to prevent running over people who inadvertently found themselves on the train tracks. Those are things that he admitted, and he admitted knowing this when he operated the train on July 4th, 1999, July 3rd, July 4th, 1999. We're not exactly precisely sure the time of the accident, although we think it was the early morning hours of July 4th. And he was speeding. The speed is established by the speed limit posted in the area, 10 miles an hour. It was established by the other gentleman on the train, Mr. Tobin, who had also run this train many, many times, who testified that when Mr. Montes commenced stopping the train, that he estimated the speed of the train to be between 20 and 25 miles an hour, more than double the speed limit. A jury easily could have found that had Mr. Montes been doing his job properly, looking forward for persons in or about the area of the track, as required by the regulations, and those are part of Exhibit Appendix 11, the exhibits that appear on pages 32.
Well, had he been doing his job properly, maybe the accident wouldn't have happened. But isn't that negligence? I mean, if I'm driving my car in a school zone, but it's in the middle of the night, and I'm talking on my cell phone and looking out the window, and someone runs in front of my car, that's negligence. I don't know if it's recklessness, though.
Well, that's why I believe it's a fact issue for the jury, as this Court has said in Commonwealth versus Levesque. And I think what's important, Your Honor, is that you look at it in the context of what else was going on at the time. Our argument is that if Mr. Montes had been doing his job, looking forward, looking for persons in or about the area of the track, and not speeding, he would have seen Mr. Montes.
What was the likelihood if he'd been looking? What is the likelihood that someone would be on the track? This is fenced in by barbed wire. This is a highly protected area. I take it your client says that he was mugged and people threw him over the fence or something of that sort?
That was his claim.
I mean, in the middle of the night, a reasonable operator of the train pulling out of a station, 25 miles an hour may be faster than that speed zone, but that's not fast for an MBTA train. And perhaps looking to the side, and all of a sudden he sees something, or thinks he sees something, stops the train, they couldn't find anybody, or couldn't find anything, and they got back in the train and proceeded on. Well, what's the high degree of likelihood that this would have happened under these circumstances?
Okay. A couple of points, Your Honor. First of all, there's nothing in the regulations that qualifies, I'm referring to the regulations, the safety regulations of the MBTA that qualifies the job of the operator to be limited to areas where they're operating on an open track.
I understand that. And you know, drivers of cars are always supposed to be looking forward and watching, and sometimes they don't, and nothing qualifies that. But again, recklessness is not just a higher degree of negligence, it's a whole different kind of animal that we're talking about here. It's something so far beyond negligence that it's different in kind. What's the different in kind here than just he really should have been paying more attention because the regulations and common sense say you should pay more attention?
It's the totality of the circumstances. It's looking at the regulations, what they require of the T operators, and the fact that he had a completely straight shot with the brights of the brights on that everybody agrees are 5 times as bright as the brights of the train on the car, as the lights on the car. It's the fact that Mr. Montes is wearing light-colored pants that the jury, and that was testified to without exception, he's wearing beige pants. Pictures of the beige pants shredded are in the exhibits that the jury saw, part of Appendix 11.
Well, why isn't that gross negligence?
It could have been gross negligence, but that wasn't an issue before the jury.
Well, if it could have been gross negligence, it couldn't have been recklessness.
Sure it could. The jury could have found either one on the facts, Judge Espina. They could have gone either way, but the only issue before them.
But I'm getting back to Justice Cordy's point. Recklessness is not a higher degree of negligence. It's a whole different animal. Where is that here?
Well, the recklessness is, and I refer the court to the Isaacson case, which dealt with the situation of violations of safety regulations. There were statutes in that particular case as opposed to regulations, but the purpose of which was the same in both cases, which is protection of safety of the public. And in that particular case, this court said that violations of safety regulations can be considered, or safety statutes can be considered as evidence of recklessness.
Correct, but doesn't that depends, it seems to me, on the, what's the nature of the risk that is posed by violating that particular safety regulation? I mean, we have a zillion safety regulations, you know, that you're supposed to do. And some of them, if you fail to meet them, pose very high risks of things. I think isn't that the one that, you know, knowing that your brakes don't work. When you drive and you know that your brakes don't work, you know that you're in an accident not just waiting to happen, but imminently about to happen, because you have to stop your vehicle multiple times when you're out there. Wasn't it the nature of that regulation in terms of the risk that it posed when you violated it? I mean, you know, you're supposed to get have lots of things in your car work, but brakes are so essential.
I think that goes to the totality of the circumstances, Justice Sussman. And I think that's what the court considered in Isaacson, the totality of the circumstances. What I think is important to keep in mind here is Mr. Montes knew that the purpose of the safety regulations were to prevent running over people who find themselves in a position of peril on the train track. Now, the jury did not find in this particular case that Mr. Montes knew or should have known that Mr. Montes was in a position of peril. The evidence could have gone either way. I didn't challenge that in the post-trial motion. There was evidence to support they could have found it. They did not have to find it. The critical question was there evidence to support the jury's finding of recklessness in this case?
Could you clarify one thing for me now? Why did they stop the train?
They stopped the train because and this is very important, Your Honor, and I'm glad you brought that up. They stopped the train because Mr. Montes radioed to Mr. Tobin saying, I thought I saw someone in or about the area of the right-of-way. The right-of-way includes the train tracks themselves. If you look at the tracks, and Mr. Montes further testified where he saw this someone was right in the area of the switch. I'd like to refer the court to one of the photographs that the jury saw in this particular case.
Could I, just so I understand that evidence, it sounds like what was happening was that probably at the moment of impact or whatnot, something told Mr. Montes that something was wrong, but not that he saw it before he hit him. I take it that the train was stopped after the accident had already occurred.
The train was stopped after the accident occurred when Mr. Montes testified that he stopped the train because he saw someone in the area of the right-of-way. Where he saw that someone, and if you look at Exhibit 5, which is Appendix page 12, he saw someone in the area of the switch. Mr. Montes' leg was found between the tracks adjacent to that switch. There's other photographs in here that show pieces of his pants. They show that's on the very next photograph, Exhibit 6. Pieces of bone also shown in that photograph between the tracks.
Correct.
Well,
but the timing is the issue. There is, I take it the jury found that Mr. Montes did not see Mr. Montes before he hit him.
I'm inferring that that's what the jury found.
Well, the question is a slightly, at least in my judgment, the question to the jury is, did he know the plaintiff was helplessly trapped on its property? I take it was framed that way because to some extent the driver had said that he thought he saw something, correct?
Well, I think it was framed that way because of the issue of trespass.
No, I understand that, but I mean, I don't see a jury finding that he didn't see. Well,
the way that there were the first two jury questions dealt with the issue of.
I understand that, but I don't.
There was no specific question posed to the jury. Did he stop the train, as Your Honor suggested, that he didn't see or did see Mr. Montes prior to impact? That specific question was not framed as a special question for the jury to consider.
Yeah, and I was responding to your response that you inferred that the jury had concluded he didn't see him.
I'm guessing because I don't know what.
It's a guess.
It's a guess, Your Honor. Our argument was if Mr. Montes had been doing his job properly and not speeding, he would have been able to control the train and stop it prior to seeing Mr. Montes' beige leg that clearly had to be draped across the track. The jury, and again, this court must view the evidence in the light most favorable to the plaintiff. The jury clearly could have concluded on the evidence that the way Mr. Montes lost his left leg, his right leg, I forget which leg he lost, forgive me. One leg was lost, the other was severely injured. The way that he lost his leg is it was draped across the train track and run over. It was found by the investigators laying between the train tracks.
But your theory was, if Mr. Montes had been, A, keeping an adequate lookout like he was supposed to, and traveling at the 10 miles per hour, he would have seen Mr. Montes and been able to stop in time.
Precisely, Your Honor.
That is your theory. Not a theory, I think that's what I asked you earlier, that he actually saw Mr. Montes and ignored the possibility that that might be a human being and deliberately rode right over it.
The jury could have found that. That wasn't what I argued to the jury.
That was not your position. Okay.
Correct.
Okay.
The jury could have so found on the evidence that they could have gone that route. We don't know what they did. You know, one never knows what a jury does in terms of their deliberations, nor do we have a right to know. But the fact that's precisely the issue as to why the question of recklessness is a jury issue, as this court said in Commonwealth versus Levesque.
Thank you, Mr. Blomowitz.
Thank you very much, Your Honor.
Mr. Sullivan?
I'd like to add a little bit to the facts, to the evidence that the jury heard in this case. The evidence was that around 1 a.m. on the morning of July 4th, 1999, that Mr. Montes was under the tracks, was in the area of the railroad tracks underneath a bridge near the Beach Street overpass near the Revere Beach Station. It was dark. There was no lighting in that area. And the area where it turns out that he apparently was, and the area where this accident occurred, is directly behind, is near a switch, but directly behind a green light that is about 3 feet above the ground. And when the train leaves the station, the light has to be green or the
But the jury heard all of that and heard about the intensity of the light, of the headlight on the train. Isn't it for them to sort out what could and couldn't have been seen, at what distance,
Certainly,
et cetera?
certainly, and I think that's what they did do when they made a specific finding in one of the jury questions, where they said that Mr. Montes, the driver of the train, didn't know or have reason to know that the plaintiff was helplessly trapped on the tracks.
But that doesn't answer the question of whether or not the jury could have found that he saw the man.
Well, I think it does. I think it does. And the reason I say that, Your Honor, is that Mr. Montes always claimed, and his attorney always claimed, that he was on the tracks lying down, was unconscious, and that his pant leg, his trouser legs were stuck on the tracks.
Right, but the
so
issue is
the
what
jury
Mr.
didn't hear any other evidence that he was in any other position.
Right, but the issue was what, from Mr. Moles's point of view, had he been looking forward, what he would have seen and what he should have appreciated from that. I mean, it may not be what the plaintiff argued to the jury, but if the evidence would support the notion that Mr. Moles saw something prior to impact, either, and just, deliberately ignored, gee, there's something on the track, it could be a garbage bag, it could be a person, it could be a dead dog, it could be anything, and just, went forward, surely that would qualify as reckless, if he had actually seen it before he hit it and did nothing.
Well, Your Honor, there was no evidence of that. And there was
Would it
no...
be inferable?
I don't believe so.
Why did he stop the train?
He stopped the train because as he went by this area, out of the corner of his eye, he saw something in between the tracks, not something on the tracks. He testified that he never saw anything on the tracks. He testified that he was looking forward, and that
Because
he...
when he testifies that he is looking forward, it seems the jury can infer that if he's looking forward, straight down the track, under bright lights, they can infer that he did see something on the tracks. He's denying it, but they could exclude that as based on his bias or whatnot. Why can't they infer?
I don't believe they can, Your Honor. And the reason I say that is that the jury saw a videotape of what Mr. Moles actually would have seen as he came out of the station. We went over there one night at midnight, and we took a video as you come out of the station, and it shows the green light that I was talking about, and it shows the tracks. and you can't see anything on the tracks. The jury actually saw what Mr. Montes would have been able to see at that time, and they saw the light that we were talking about that really obstructed the view of any train driver coming out of that station. And so they saw it, and they heard all of that evidence, and they found that there was that Mr. Montes didn't know of the existence of this fellow on the tracks, helplessly trapped, or have reason to know that he was on the tracks.
So the video shows that even if the engineer were looking forward, he would not have seen a person lying across the tracks at any point in time.
There was never any evidence that there was a person lying across the tracks. The only portion of his body that it was injured was the lower left extremity below the knee. So clearly he was not lying across the tracks, or he would have been killed. So there was no evidence whatsoever that he was lying across the tracks. The only portion of his body that was on the tracks, and this is clear in the evidence, and he was claiming was his foot. And when we went that night, we did the video, we took the video, and the video was shown to the jury. It clearly shows that. So
you could not have seen somebody who was lying to the side of the tracks.
It was not. It would have been impossible, based on that video.
Mr. Sullivan,
Yes, sure.
if you finished your answer to Justice Spina, could you address, if you could, the evidentiary question? Because I take it that all this jury heard was the plaintiff's claim that he had been assaulted and then thrown over and dumped, correct?
That's correct, Your Honor.
And the jury was not permitted to hear other statements that he had made about stumbling onto the track after heavy intoxication, correct?
That's correct, Your Honor.
I mean, I've read your brief. It seemed to me that when you're looking at a situation of contributory negligence, if the jury is not informed of that, aren't you at somewhat of a disadvantage?
I felt that I was, Your Honor, and in anticipation of that, I brought a motion to depose the psychiatrist involved. The prior statement that Mr. Montes gave, actually he gave 3 different statements concerning the occurrence of this accident. When he was first brought into the hospital, Officer Bashuko from the MBTA police came and asked him what happened. He said he had no memory of any accident. He didn't know how it happened. The next day, a nurse asked him what happened. He said he didn't know. He had no idea what happened in the accident.
But those came into evidence, cross-examination.
That came into evidence,
Sure.
Yes, Your Honor. A few days later, he was questioned by a psychiatrist, and he told the psychiatrist that he told them that he had been drinking, that he had some beer, and that he was in the station. He thought the train was stopping, and he stuck out his leg trying to get on the train, but the train didn't stop, and amputated his leg. And at first, he didn't know why he couldn't walk, and then he became aware that his leg had been amputated. I believe that if the jury heard that evidence, that there certainly would have been a different verdict in this case, because the credibility of this witness, Mr. Montes, was at issue, first of all. And I was not allowed to cross-examine him and confront him with that statement.
I take it, and I haven't looked at your closing argument, but I take it, I don't even know if it's in the record, but I take it that essentially what the jury heard was, I was assaulted and I was thrown over, and immediately after the accident, I didn't remember that. Correct?
No,
I mean,
Your Honor.
because
No, he never claimed that he didn't remember that, Your Honor. He claimed when he went to the hospital, he was asked what happened, and he said, I don't know.
That's what I mean.
I don't remember any accident. 3 days later, he's asked by a psychiatrist what happened.
No, I understand. But so in response to Justice Cordy's question, you said the jury did hear about the first 2, the MBTA.
Yes, they did.
But the jury could have concluded from that a reasonable inference is this is an immediate aftermath of a massive trauma. So the fact that I don't remember that I was assaulted
Sure.
and thrown on, those are not inconsistent.
Certainly, Your Honor. To give them the benefit of that, I suppose they could have. However, when he was asked the questions by the psychiatrist.
No, I understand. So the psychiatrist, the evidence of what he said to the psychiatrist is considerably different from what he said on the first 2 occasions.
That's correct, and it's also different than what he said at the trial, Your Honor, because he was claiming that he was robbed, hit on the head, and thrown on the tracks. There's a stark difference.
He also claimed that he was unconscious with his legs on the track.
That's correct, Your Honor.
And was awakened by the vibrations and couldn't get his leg off the track in time, as opposed to he was trying to get on the train and the train didn't stop.
That's correct, Your Honor.
Which creates a very different issue about what perhaps could have been seen. Was there really something on the track at all?
That's correct, Your Honor, and it also goes to what our defense was. Our defense was that there was comparative negligence there, and he was actually responsible for the accident.
Well, comparative negligence, at least on a theory of recklessness, as I understand it, comparative negligence doesn't apply, and that's why recklessness is treated so differently.
That's correct, Your Honor, but it wasn't a recklessness case at that point.
Okay.
The jury found that he was a trespasser, which made it a recklessness case. When I was trying the case, it was a negligence case.
Moreover,
But it affects causation, it affects what could have been seen, it affects many different aspects of how this whole evidentiary picture could be interpreted.
Yes, it does, Your Honor, and also I'd like to point out that I feel that it was admissible, even though we have this psychiatric privilege, that it was admissible because his mental state was an issue in this case. He was claiming he was unconscious. The statement says he was conscious. We know he was intoxicated, and that also has to do with his mental condition at the time.
Mr. Sullivan, could you explain to me the circumstances? I'm really trying to find out if there's even a basis for the I know that the doctor is a psychiatrist. Could you explain to me the basis under which the psychiatrist was interacting?
Yes,
how soon after the accident, and what was the nature of the relationship?
Yes, Your Honor. The psychiatrist was called in to evaluate whether or not there was some alcohol withdrawal problems. When, at the time of the accident, we put on an expert who said his blood alcohol was 0.15 to 0.25. The next morning at the hospital, around 8 in the morning, his blood was tested. He had a 0.15 blood alcohol level. They did some surgery at the hospital at 1 p.m., full 12 hours after the accident. The hospital record says he was still intoxicated, and so they were giving him withdrawal drugs for withdrawal from alcohol. That was the purpose for the visit with the psychiatrist. It really had nothing to do with any other psychiatric issues, and had to do with, and I think that they also were investigating whether or not this was an attempted suicide. But the record shows that they continued to give him the alcohol withdrawal medication for several days afterwards. I feel that I was denied the right to cross-examine Mr. Montes. His credibility was an issue in this case. Mr. Montes, on another issue concerning his employment, admitted perjury in this same trial. He testified in his direct testimony that he had never worked.
But you were able to get that out and cross-examine on that subject, and the jury heard all that.
I certainly did, Your Honor. And so the jury knew that he committed perjury on that issue, but they weren't told that he had given a totally different story shortly after the accident as to the occurrence of the accident, how it occurred, and I believe that would have put this case over the edge. This would have been a defendant's verdict if they heard what he had to say to the psychiatrist. I believe that my right of impeachment of this witness was taken away, and I cite in the brief, I think what is the key case in this whole area and the Harris case, which was a criminal case where a defendant gave a statement to the police, but the Miranda rights were not given to him. He then took the stand and told a version different than the original statement, and the Supreme Court of the United States said that the privilege against the Miranda rights being violated, he shouldn't be able to hide behind that privilege, and it shouldn't allow him to commit perjury in a case where it's clear that everyone knows that he gave a prior statement in the past. In this case, the court knew, the attorneys knew, everyone in the courtroom knew that this fellow had given a statement totally different than what he was testifying to at trial. The only ones who didn't know it were the jury, and I feel that I should have had that right to cross-examine and impeach his credibility.
I don't have the record appendix with me here. Was there a written decision? This was a motion in limine, correct?
Your Honor, it was originally a motion to depose the psychiatrist.
Right.
Then there was a motion in limine to,
So you did
Prior to
depose,
trial.
you did depose the psychiatrist?
no, Your
Oh,
Honor.
you
I
did
was-
not.
I was denied the right to, I made a
Oh,
motion
no,
to depose.
you had the statement given to the psychiatrist, but you didn't have,
I didn't have the testimony.
Right, okay.
My intention was to depose, and prior to
I'm sorry.
trial, I made a motion to permit me to put that into evidence. I made an offer of proof during the trial while the plaintiff was on the stand as to the reasons why I felt that it was
So
admissible.
you preserved all your rights.
Yes, I did, Your Honor.
Did you appeal?
Yes.
yes. Oh,
Yes,
yes, and it's
cross-appeal.
back up here.
Based on your Harris theory here, is this you would have been able to put this statement in, well, what if the defendant hadn't testified, or the plaintiff hadn't testified?
Your Honor, my argument was that it was admissible as to his mental condition. His mental condition was relevant. What the plaintiff tried to do is say, I'm taking that out. I'm not claiming damages for mental
I guess my point is this one. Even if this were clearly covered by the psychiatric privilege, and your suggestion here is that it's really not clearly covered, or at least
That's
if it's
correct.
covered, there's an exception.
Yes, sir.
If it was clearly covered, your argument would be under the Harris case, it wouldn't matter, because once he got on the stand and testified to a different story, that opened this up. Is that
That's
your
correct,
position?
Your Honor.
Thank you, Mr. Sullivan.
Thank you.